This is a reviewer for double sales. So under the lawn sales and then also touching on the property registration decree. So first, general overview. Under Article 1544 of the Civil Code, what is a double sale? The requisites for a double sale to exist are fourfold. Actually, I'm going to run through just very quickly bullet points, and then we're going to go in depth so I can just listen to the first 5 minutes of this when I need to review. Okay, the requisites for a double sale to exist are fourfold. First, 2 or more sales transactions must constitute valid sales. Second, 2 or more sales transactions must pertain to the same object or subject matter. Third, 2 or more buyers at odds over the rightful ownership or the subject matter must each represent conflicting interests. And then fourth, 2 or more buyers must each have bought from the same seller. So the 4 requisites for a double sale to exist is that there is a multiplicity of transactions which constitute valid sales. So valid sales transactions, multiple valid sales transactions that pertain to the same object or subject matter, and these 2 or more buyers are at odds over the rightful ownership or the subject matter must represent conflicting interests. And the multiple buyers should have each bought from the same seller. So identity of the seller, multiplicity of transactions that constitute valid sales, and then identity of the object or the subject matter, and then the purchasers or the buyers have to be at odds for ownership, and then the subject matter has to represent conflicting interests. All right, easy. That's 1544 double sales. Now, 1544 also gives the rules for double sales depending on whether or not the thing that is sold is a movable or an immovable. So, the rule if it's a movable is that the owner is the one who first possesses the thing in good faith. So, first to possess in good faith if it's a movable. Now, if it's an immovable, it would be the first to register the thing in good faith. Immovable, first to register in good faith. Movable, first to possess in good faith. Now, more for immovables, if there's no inscription, then it is the first to possess in good faith. So, no registration, then it would be, you'd go to the secondary rule, which would be first to possess in good faith. Now, if there was no inscription and no possession in good faith, then it would be the person who presents the oldest title in good faith. So, for immovables, it's going to be first to register. Lacking that, first to possess. Lacking both registration and possession, then it would be the person who would present the oldest title in good faith. Those are the rules under Article 1544. Now, some concepts that are just kind of important for double sales. First, lis pendens, which is notice that the subject matter is in litigation. Second, an adverse claim is that notice that somebody is claiming a better right. Possession here can be actual or constructive. And what do we mean by registration? This would be in the books of the registry, entries made in the registry which record and the records solemnly and permanently record the rights of ownership and other real rights, okay? So, quick bullet points on double sales. Now we're going to go into the nitty-gritty of double sales. Okay, so 1544, this is what you're going to quote again when you talk about double sales. The requisites, what are they? 2 or more valid sales, so 2 transactions, valid sales, different buyers, same object of the contract, conflicting interests between buyers, and the same seller. Why is it now 5? Or earlier it was 4. Why is it 5 now? Hold on. How did I say it earlier? 2 or more sales transactions must constitute valid sales. 2 or more sales transactions must pertain to the same object or subject matter. The buyers are at odds. Oh, okay. It just separated that there have to be 2 or more buyers. But then, yeah, there's 2 or more transactions. There's no identity of the buyers. Whatever. That's why it got split into 5. The buyer thing became like its own number. Anyway, multiple valid sales, different buyers, same object, same seller, and buyers have conflicting interests. Now, for movable properties, the rule, again, is the first person who takes possession of the thing sold in good faith would then be the owner of that thing. If it's immovable property, you have the steps for the rules. First would be the first person who registers the sale in good faith becomes the owner. So, if you're the first person who would register the sale of that thing to you, you're in good faith, then you're the owner. If both buyers had failed to register the property in the registry of deeds, then it would be the first person who takes possession of the immovable thing in good faith who would take ownership of the property. Now, if there is a failure of both inscription and possession, so both buyers or all buyers, if there's multiple, like he's not just a double sale, it's, you know, a quintuple sale, whatever. This guy is just finding everyone on Facebook Marketplace. Okay, anyway, so if there's a failure of the buyers to register and also no one took possession, then it's going to be the person who could present the oldest title who would take ownership. Now, for immovable property and also for movable property, actually for all of this, for ownership to be vested, the condition of good faith is needed. So if it's movable and you take possession, you have to take possession in good faith in order to get that ownership over the thing. Immovable, first to register the sale, first to take possession, barring both of those or lacking both of those, then it's going to be the person with the oldest title. And again, everyone has to be in good faith. Now, for immovable properties, there are some additional rules. What if the case is the first buyer fails to register and take possession of the property wherein he is evicted from the property he was supposed to claim? Okay? The case is the first buyer fails to register and take possession of the property, then he is evicted from the property he was supposed to claim. Sorry, because he was evicted from the property he was supposed to claim. What then is the remedy of this first buyer? The first buyer has the remedy to bring an action against warranty against eviction, and they would bring this action against the seller, okay? So, if the first buyer is evicted from the property that he was going to claim, and because of this eviction, that first buyer had failed to register and take possession of the property. Oh no, so how's he gonna get ownership now, right? Well, his remedy is actually to bring an action against the seller for violation of the warranty against eviction. Now, for this to happen, however, though, the second buyer who, got ownership because the first buyer had failed to register and take possession of the property, right? So, second buyer then would get ownership based on good faith. They have to have been in good faith. So the second buyer who gets ownership based on the failure to register and take possession of the property by the first buyer because the first buyer was evicted, this second buyer needs to be in good faith. And what does this mean? No prior knowledge of the defect in the title, even before buying the property, after buying the property, and even when they are registering the property. So second buyer only gets ownership in this case if they are in good faith. Now, if the first vendee, so if the first buyer is aware of the fact that there was a double sale, so first buyer now finds out, the seller is shady, they sold it again to another person. What happens then? The first buyer would still have the rights to the property provided that they had registered the property already. So when the first buyer becomes aware of the double sale, their rights to the property are preserved so long as they had registered the property already. Okay, that's Article 1544, the rule as to double sales. Okay, movable, first to take possession; immovable, first to register, or the first to take possession. Failing both, it would be the oldest title. If the first buyer fails to register and take possession of the property wherein he was evicted from the property that he was supposed to claim, the remedy is to bring an action against warranty, against eviction, and bring this action against the seller. Now, it must be noted that the second buyer must be in good faith. What does good faith mean? No prior knowledge of a defect in the title, and this good faith would be assessed before buying the property, after buying the property, and even in the registration of the property. If the first vendee is aware of the fact that there's a double sale, that first vendee still has the rights to the property provided that they had registered the property already. Okay, let's backtrack a bit and actually state the codal provision. So we stated the rules which are found under Article 1544. But what does Article 1544 actually state? How does it read? Article 1544 of the New Civil Code says, if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession thereof in good faith, if it should be movable property. Should it be immovable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property. should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof, to the person who presents the oldest title, provided there is good faith. So that's Article 1544. Now, there are other provisions on double sales in the new Civil Code, one of which is Article 1165, specifically Paragraph 3. Paragraph 3 of 1165 reads, if the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Now, 1165 says essentially what happens when the obligor is in delay, but it also says that the effect of when the obligor is in delay will also happen when there is a double sale. And the effect of this is that the obligor shall be responsible for any fortuitous event until delivery has been effected. So remember, however, that the new Civil Code is the general law, and then there are more specific laws such as the Property Registration Decree. 1544. While it contains the rules on double sales, it's not the only existing and prevailing rules on double sales. There are more, and we'll get into that. But taking another step back, what exactly is a double sale? A double sale, if you have to define it not by the elements, you would just say it is a situation where the same seller has sold the same property or the same subject matter, the same subject property to two or more buyers who do not represent the same interest. Okay? Then you get the 4 or 5 elements from earlier. So a double sale is a situation where the same seller sells the same subject property to two or more buyers, and these buyers do not represent the same interest. Now, double sales is considered under the realm of tradition. Why? Because the various rules on double sales under 1544, other special laws, and 1165, what are you talking about here? You're talking about the consummation stage of the contract of sale. So the rules on double sale are essentially talking about the effects and the consequences of tradition in a double sale. The various rules on double sales become operative when certain circumstances are present. And which circumstances are these? First, there are conflicting sales that are valid and demandable sales. So you have two or more transactions which constitute valid and demandable sales. Pursuant to these transactions, tradition was or could be effected. Second, the owner who effected multiple sales to various buyers over the same subject matter actually had ownership to convey. So that's again why it's valid, because the person selling it had ownership over that thing and could validly sell it and transfer ownership through what? Tradition. Now, essentially, the rules on double sales under 1544 are basically rules on preference. And these are, to sum it up again, if it's personal or movable property, it's the first possessor in good faith. If it's real or immovable property, then it would be the first registrant in good faith. The second buyer must register the document in good faith, otherwise he does not have a better right. Okay? First registered in good faith. Second buyer, if they don't register that document at all, they don't have any better right. Then it would be, the second buyer must register the document in good faith, otherwise that second buyer would not have a better right. Just because the first registrant failed to register. Okay? Then failing both registering, it would be the first possessor in good faith, and failing both of those, person with the oldest title in good faith. Those would be the rules and preference for double sales for immovables. Okay, now let's get into more nitty-gritty on the rule on personal or movable property. Now, the main rule, if you want to say it in Latin, would be prius tempore potior iure. But don't say it in Latin because it's hard to spell and pronounce. So this means, however, first in time, priority in right. So the buyer who first possesses the movable in good faith is preferred. So that's just the main rule. First time, priority in right, whatever. The buyer who first possesses the movable in good faith is preferred. The main rule, however, is not the primary rule. Think about that. in your noggin. Okay, the provisions under Article 1544, although not the main rule, constitute nevertheless the primary rule for personal or movable property in the case of double sales. One has to go through, however, the tests provided for in Article 1544 before one may apply the rule of first in time, prior in right. Okay? Time, priority, and right is embodied within the oldest title in good faith provided under Article 1544. All right. The main rule, again, is first in time, priority, and right. The buyer who first possesses the movable in good faith is preferred. Okay, now make whatever the hell I just said make sense. Basically, the primary rule is under... Sorry. The main rule is not the primary rule, and the main rule is first in time, priority, and right. The provisions of Article 1544 are not the main rule, but they provide the primary rule that one has to go through the test provided in Article 1544 before one may apply the main rule of first in time, prior, and right. This makes more sense when you read it with other articles of the Civil Code. Now, oldest title in good faith is embodied or provided for in 1544. Possession and enjoyment of movable property are considered to be the best gauge available to the public to determine who owns a movable property. So possession and enjoyment, when you're talking about a movable property, you see someone using a car, driving a car, parking that car in their garage. It's the best gauge for you as the public to know who essentially is the owner of that car. You'll be like, oh, that guy probably owns that car because of, you can see the possession and you can see the enjoyment. No, sorry, I mean, you can see the enjoyment of the movable property, okay? Now, Article 559 says that the possession of movable property acquired in good faith is equivalent to a title. So under 559, if you're possessing a movable property in good faith, this is equivalent to title. The article continues, however, so 559 continues. Nevertheless, one who has lost any movable, or has been unlawfully deprived thereof, may recover it from the person in possession of the same. So, it would seem under 559 that finders, keepers, losers, weepers, right? Possession of the movable title acquired in good faith is equivalent to a title. But not really, because you are not in good faith if you acquire the possession of this movable property just by like finding it. So that's not equivalent to a title. So the second part, which says that if you've lost that movable, if the person has lost any movable or has been unlawfully deprived thereof, so say it was stolen from you, you can still recover that thing from the person in possession of the same. So someone stole your phone, you find someone else with your phone, you can get that phone back from that person in possession of it. Now, the second paragraph of 559 says that if the possessor of a movable lost or which the owner has been unlawfully deprived has acquired it in good faith at a public sale. So someone stole your phone, a third person, not the person who stole your phone, acquired this phone in good faith at a public sale, the owner cannot obtain its return without reimbursing the price paid therefor. Why? Because they purchased it in good faith at a public sale. So, general rule, possession of a movable property acquired in good faith is equivalent to title. Okay? But if the person who lost that movable or was unlawfully deprived of that movable, that person still has a right to recover possession of that movable from the person in possession of the same. Sorry, the person has the right to recover that movable from the person in possession of the same. So, possession acquired in good faith, equivalent to title. But the person who lost it or was deprived of it by unlawful means has a right of recovery against the possessor of that movable. Now, if the possessor of that movable had acquired it at a public sale and in good faith, then the person who lost it or who lost it or was unlawfully deprived of it is still the owner, right? And they still have a right to recover the thing from the person in possession of it. But because it was acquired in good faith at a public sale, then the owner must reimburse the possessor the price paid therefor for that movable property. So, possession of movable property acquired in good faith is equivalent to title, and this can be interposed against even the real owner. So, there. The rule on personal or movable property. First in time, prior in right, the main rule, that's the main rule. This is not the primary rule, since the provision under Article 1544, although not the main rule, constitutes nevertheless the primary rule. One has to go through the tests provided for in Article 1544 before one may apply the main rule of first in time, prior in right, which is, you gotta be in good faith. The buyer who first possesses the movable in good faith is preferred. Okie dokie. And how is this first in time, prior in right embodied under oldest title in good faith? Because under 559, possession of a movable property which is acquired in good faith is equivalent to a title. And again, if you've lost it or you were unlawfully deprived of your movable property, you have the right to recover it from the person in possession of the same. However, if this person purchased it in good faith at a public sale, then you as the owner still have to reimburse the price paid therefor. And possession of a movable property acquired in good faith is equivalent to title, which may be interposed even against the real owner. Now the rules on real or immovable property. This is where the property registration decree can come in, okay? The rule on double sales under Article 1544 does not overcome the rules provided for under Presidential Decree 1459 or the Property Registration Decree. Why? Because the Civil Code is a general law and the Property Registration Decree is specific. Okay? And remember, the rules under 1544 are not the only existing and prevailing rules on double sales. So, under Property Registration Decree, under the Property Registration Decree, you get the concept of the primacy of the Torrens system of registration. So 1544 says, first, to register in good faith, then first possessor in good faith, and then the person with oldest title in good faith. And if it's the first registered in good faith, the second buyer still has to register the document in good faith. Otherwise, they wouldn't have any better right, even if the first buyer failed to register, right? Okay. So under the Torrens system of registration, there's primacy of the Torrens system of registration. There's a primacy given to the Torrens system of registration. So real property in the Philippines is governed by a system of registration. And the general rule is that the sale of land, once consummated, is valid, regardless of the form it may have been entered into. So the general rule, a consummated sale of land is valid regardless of form. So whatever form the sale of land was entered into, it's valid once consummated. The exception to this general rule is that in the event that a third party disputes the ownership of the property, so there is a third party here, not the seller, not the buyer, someone is disputing that the person who is registering this property, the event here is that a third party is disputing the ownership of the property, okay? In that event, if the sale of land was consummated in like a verbal form, there is no means to enforce the contract if it is not in a public document. So, general rule, sale of land, once consummated, is valid regardless of form. However, if in case there is a third party that disputes the ownership of the property, then there's no means to enforce that contract of sale of land, even if consummated, unless that contract of sale of land was contained in a public document. So the enforcement of the contract for sale of land is dependent on its form, and it is only enforceable if it is embodied in a public document. Okay? Statute of frauds, right? I think? Yes. Yes, it is a valid but unenforceable contract. Now, registration with the Registry of Deeds is what binds registered land. Again, the act of registration of the registered land with the registry of deeds is the binding act upon that land. Now, Article 1544, going back, it says that the buyer in good faith who is able to effect registration of his purchase is preferred. So the rule of preference under Article 1544 for real or immovable property first goes to the buyer in good faith who first was able to effect registration of their purchase of the land, right? And again, registration is the act which binds the registered land, registration with the registry of deeds. So that makes sense. Now, how do we move on to the second step? If the first buyer and also the second buyer did not register the land, you go to the first possessor in good faith, right? Now, this is consistent with the principle that the sale, even when it is valid and enforceable, is merely a title or legal justification to acquire ownership. Now, remember, sale is not one of the modes of acquiring ownership, right? It's tradition, the delivery of the thing, right? That would give you the ownership. You purchase something, and then when it's delivered to you, that's when you get the ownership. The sale itself is merely a title or a legal justification for the acquiring of ownership, but it is not a mode of acquiring ownership. The mode of acquiring ownership, so where ownership is transferred from the seller to the buyer, is actually tradition. And remember, because of this, the seller actually has to be able to transfer ownership. The seller should have authority. The seller should be the owner. Or if it's an agent, they should have that authority. And just as as an aside, in general, the contract of sales, right? The contract of sale of land is valid regardless of the form that it may have been entered into, but it would just be unenforceable if it wasn't embodied in a public document. However, if that sale of land was effected through a agent, and that agent does not have their specific power to sell that land in written form, then not only is the contract of agency not valid, the act not binding upon the principle, but the very sale itself would be void. The sale of the land itself would be void. Okay. So possessor in good faith, consistent with the principle that the sale, even when it is valid and enforceable, is merely a title or legal justification to acquire ownership, because it is tradition that is the mode by which ownership is transferred to the buyer. And that's why possessor in good faith is the secondary one. So because of the Torrent system of registration, you get the primacy, and 1544, that first to register in good faith, right? These both make sense. Real property is governed by a system of registration. So the buyer who in good faith is first able to effect that registration of their purchase would be preferred. Then the justification for first possessor in good faith is because the possession here would be akin to like tradition. So the fact that they were able to take possession of it seems, and then they have that contract of sale. So the contract of sale would be the title or legal justification for why they could acquire ownership through tradition, or they took possession, okay? And then the last one would be barring both of the previous rules of preference taking place, so registration or possession, then it would be the person with the oldest title in good faith. And this adheres to the principle of what? First in time, prior in right. So the buyer with the oldest title in good faith should be preferred. So there's a hierarchy, again, for the rule of preference when it comes to real property. The first being the first registered in good faith, and the second buyer still has to register the document in good faith, otherwise they do not have any better right against the first buyer. The second in the hierarchy is the first possessor in good faith, and then the third would be the person with the oldest title in good faith. Now, going specifically to land, there are two divergent systems when it comes to land. So when you're talking about land, you have to first see whether it falls under the system for registered land or if it falls under the system for unregistered land. Now, registered land is going to be covered by the Torrent system. Remember, there is a primacy granted to the Torrent system of registration. Now, the Torrent system is under Presidential Decree number 1529, or the Property Registration Decree. Registered land, you're going to look at the torrent system. Now, what if it's unregistered land? This is not covered by the torrent system. Doi, okay? Like, wow, easy. Registered, torrents, unregistered, not torrents. Okay, so it's not torrents. So what then is the system that governs unregistered land? This would be Act number 3344, but it's also provided for in Presidential Decree 1529. So the property registration decree is also still relevant. Now, the torrent system, what is it? As a general overview, it's basically that the government is required to issue an official certificate of title, and this certificate of title attests to the fact that the person named in the certificate of title is the owner of the described property, subject to the liens and encumbrances noted therein or reserved by law, such as in the case of statutory liens. Like, if there is extrajudicial settlement of the estate, there's going to be like a 2-year thingy on the title, right? So creditors will know about it. Okay, that's statutory. That's placed on it because of, I want to say, the civil code, or it could be the rules. Not sure. Anyway, the certificate of title is indefeasible and imprescriptible, and all claims to the parcel of land are quieted upon the issuance of the certificate of title. So you see how supreme the torrent system is. This certificate is indefeasible, it's imprescriptible, and if you have a claim against over that parcel of land, once this certificate is issued, that claim is quieted. So it's a system where the government can essentially settle disputes over parcels of land because you can just rely on this torrent's title. Okay, it's an official certificate of title where the government itself is attesting to the fact that the person named in this certificate that the government issues, this person is the owner of the property, subject, of course, to any liens and encumbrances noted within that certificate itself or reserved by law. Now, the torrent system, again, applies to registered land. Section 51 of PD 1529, or the Property Registration Decree, talks about conveyances and other dealings by the registered owner. An owner of registered land may convey, mortgage, lease, charge, or otherwise deal with the same in accordance with existing laws. He may use such forms of deeds, mortgages, leases, or other voluntary instruments as are sufficient in law, but no deed, mortgage, lease, or other voluntary instrument, except for a will purporting to convey or affect registered land, shall take effect as a conveyance or bind the land, but it shall operate only as a contract between the parties and as evidence of authority to the Registry of Deeds to make a registration. The act of registration shall be the operative act to convey or affect the land insofar as third persons are concerned. And in all cases under this decree, the registration shall be made in the office of the Register of Deeds for the province or the city where the land lies. Again, for the conveyance and other dealings by the registered owner, Section 51 of Presidential Decree 1529. So we're talking about when so you're the owner of registered land, right? What are you allowed to do? You can convey this land, you can mortgage it, you can lease it, charge it, or otherwise deal with this land in any similar way in accordance with existing laws, right? This is an exercise of ownership. And how can this be done? Through deeds, through mortgages, through leases, voluntary instruments, so long as they are sufficiently complying with what the law requires for these instruments, right? However, and this is an important thing, so the owner can exercise its ownership over the land, right? But then the conveyance and other dealings by the registered owner, Section 51, says that no such instrument, no such deed, mortgage, lease, or other voluntary instrument, except for a will that purports to convey or affect that registered land, shall take effect as a conveyance or bind the land, okay? So any mortgage, lease, or voluntary instrument entered into by the owner of the registered land, it doesn't take effect as a conveyance and it doesn't bind the land. It only operates as a contract between the parties, so the registered owner and whoever they're entering into this mortgage, lease, or other voluntary instrument with. And it would only be evidence of authority to the Registry of Deeds to make registration, okay? So these mortgages, these leases, they don't convey the land. They don't transfer the ownership of the land, and they don't bind the land. They only bind the parties to these voluntary instruments, okay? And what you would use this for, so if you would mortgage this land and say there was a foreclosure or something, right? Or you lease it, whatever. If you want to bind the land, this contract is insufficient to actually bind the land. Because the operative act that would bind the land is the registration. The act of registration with the Registry of Deeds. It is that act of registration that would bind third persons or affect the land insofar as third persons are involved. Okay? Otherwise, it's a contract between the parties, and it would just be evidence of the authority of the Registry of Deeds to make registration. So you can give it to the Registry of Deeds and then be like, oh, okay. And then they can then use this voluntary instrument to bind the land, but you got to register it. So the operative act is registration. Any other voluntary instrument is simply a contract between the parties, and it cannot bind the land. There is an exception, okay? In general, any of these voluntary instruments don't bind the land. They do not take effect as a conveyance, and they do not bind the land. They operate only as a contract between the parties. The exception is if it is a will. If it's a will purporting to convey or affect the registered land, then this rule does not apply, okay? The act of registration then would not be the operative act to convey or affect the land because the will can do it on its own. Any other voluntary instrument does not have that power. Okay, now, what is registration? Registration is the judicial or administrative process by which a parcel of land is placed for the first time within the coverage of the torrent system. One more time. Registration is the judicial or administrative process by which a parcel of land is placed for the first time within the coverage of the torrent system. Now, there would be an annotation or inscription with the registration of deeds in case there is any contract, transaction, or legal process involving real estate, such as a mortgage, lease, charge, or other voluntary instrument involving that registered land or that real estate, okay? Registration, first time it's placed within the coverage of the torrent system. If there's any other contract or transaction or legal process that would involve that real estate that is already registered, this would be put in as an annotation or an inscription. Okay, that voluntary instrument would still be registered by the Registry of Deeds, but then they wouldn't give you like a new title. They just like annotate it on the existing one. So let's compare 1544 and PD 1529. So Article 1544 of the New Civil Code compared to 1529. Remember, they're both rules concerning double sales, but 1529 is specifically for registered lands covered by the torrent system. Now, 1544, it covers only the annotation or the inscription within the Registry of Deeds of a contract, transaction, or legal process involving real estate. Why? Because what has to be registered under 1544? The contract of sale. The first person to register that contract of sale is in good faith, is the one who gets preference. So 1544 talks about that annotation or inscription with the Registry of Deeds of a contract, transaction, or legal process that involves the real estate. And it applies, of course, only to double sales situations because it's a rule for double sales. And under 1544, these rules do not overcome nor preempt the specific rules under the torrent system for registered land. Why? Because the New Civil Code is a general law. 1544, again, remember, is strictly applicable to double sales only. So the scope of 1544 is just double sales. So they have to be there have to be two valid sales, different buyers with conflicting interests, same seller over the same subject property. Okay? They're sales that are valid, they're demandable, and the issues arise only from the consummation stage of the sales. Okay? We're talking about who actually gets the ownership now by tradition. Okay? On the other hand, the scope of PD 1529 is all forms of annotated voluntary contracts and transactions. So not just double sales, we're talking about leases, we're talking about mortgages, we're talking about charges, options, agency, designation, contracts to sell. Any type of voluntary contract, instrument, or transaction involving real property, revolving land. And registration under PD 1529 is the operative act by which the dealing, so these voluntary contracts, transactions, leases, mortgages, options, agency designation contracts to sell. This is how these dealings over the registered land, whether they be voluntary or involuntary, become recognizable as existing, and they become binding upon third parties. No registration, no binding upon third parties. It would only be a contract between the parties to that contract. Okay? You get it? I get it. Okay. The certificate issued, however, under the case of Liao versus Court of Appeals, LIAO versus Court of Appeals, it says that the certificate is not conclusive evidence of title, however, if the same land has been registered and an earlier certificate for the same is in existence. I tried to say that too fast and then I got dizzy. So, the general rule is the certificate of title under the torn system is indefeasible and imprescriptible, and all claims to the parcel of land are quieted upon the issuance of the certificate of title. Okay? The government issues an official certificate of title that attests to the fact that the person named in that certificate is the owner of the described property, subject to any liens or encumbrances. That's the torrent system, right? And then under that, registration is when there is a judicial or administrative process and a parcel of land is placed for the first time within the coverage of the torrent system. So both of those together, it makes sense why there is an exception now under Liao versus Court of Appeals. The certificate is not conclusive evidence of title in the exception situation, where the same land had already been registered and there is existing an earlier certificate for the same land. Okay. Next, under Naawan Community Rural Bank versus Court of Appeals, invoking the rule on double sales and priority in time under Article 1544 would be misplaced by a first buyer who bought the land not within the torrent system, but under Act 3344, as against the second buyer who bought the same property when it was already registered under the torrent system. So, okay. The rules on double sales and priority in time under 1544 cannot be invoked by a first buyer if that first buyer bought the land not within the torrent system, but under Act 3344, and this first buyer is trying to invoke this against a second buyer who had bought the same property, when it was already registered under the torrent system. So, under Naawan Community Rural Bank versus Court of Appeals, this is the situation being contemplated. First buyer buys the land, but it's not yet within the torrent system, okay? Then there's a second buyer, and by the time this second buyer bought the same property, it was already registered under the torrent system. So, here, the rules on double sales and priority in time under 1544 do not apply. Why? First, because there's a well-known rule in this jurisdiction that persons dealing with registered land have the legal right to rely on the fact of the torrent certificate of title and to dispense with the need to inquire further. That's the whole point of the system, so that you don't need to further inquire. You're already assured by the government that, like, okay, the person here is the owner. I guess I'm dealing with that person. They have the right to sell me this land, okay? There is a legal right to the buyer to rely on the fact of the torrent certificate of title and then to dispense with any need to inquire further and still be remaining in good faith as a buyer. Except, so general rule, can rely on the torrent title. Exception, if the party concerned had actual knowledge of facts and circumstances that would impel a reasonably cautious man to make such inquiry. So while the torrent title is indefeasible, imprescriptible, it is basically on its face evidence like, okay, this is who owns this property. If the whole thing was sketchy as hell, for your own sake, make some reasonable inquiries besides just looking at the title, okay? Second reason why it doesn't apply under Naawan Community Rural Bank versus Court of Appeals, the torrent system rule that formal registration proceedings undertaken on the property and then the subsequent issuance of a title over the land had under the torrent system. This had the legal effect of cleansing the title on the property of all liens and claims not annotated therein. Remember, the second buyer here, it was already registered under the torrent system. So the second reason, the torrent system rule that formal registration proceedings undertaken on the property, and then there's a subsequent issuance of the title, of the torrent's title. It has the effect of quieting all liens and claims not annotated therein. Okay, so that's for registered land. Easy, that's the system under registered land, so you have the torrent system. What about unregistered land? Okay, here, the principle for unregistered land, which is again not under the torrent system, the principle is that registration is without prejudice to a third party with a better right. This is embodied under Section 113 of the Property Registration Decree. Again, the principle is registration is without prejudice to a third party with a better right. Section 113 states that recording of instruments relating to unregistered lands, no deed, conveyance, mortgage, lease, or other voluntary instrument affecting land not registered under the torrent system shall be valid. So general rule, no deed, conveyance, lease, or other voluntary instrument can be valid if it's trying to affect land that's not registered under the torrent system. Exception, except as between the parties thereto, so it's valid as a contract, unless such instrument shall have been recorded in the manner herein prescribed in the office of the Register of Deeds for the province or the city where the land lies. Okay? Not valid to affect registered land. Not valid if it's trying to affect land not registered under the torrent system, except between the parties, but it's still valid. So basically, it can't affect the land, but it can be a contract between the parties, unless that instrument was recorded in the Registry of Deeds. It shall be understood that any recording made under this section, however, shall be without prejudice to a third party with a better right. So, you got a conveyance, a mortgage, a lease, or other voluntary instrument, right? It can't affect the land, but it can be a party between you guys. It can be a contract between you guys, the parties. It can be a contract between the parties. It is a contract between the parties. It's still valid as that, but it can't affect the land unless you register it with the Registry of Deeds. Register of Deeds. However, even if you do that, even if you do record it, it shall still be without prejudice to a third party who has a better right. Registration is without prejudice to a third party with a better right. So registration under Section 113 of PD number 1529, which again contemplates unregistered lands under the torrent system. This registration would have legal effect only if it is consistent with the principle of protecting a third party with a better right. If there's a third party with a better right, you're shit out of luck. So essentially, this refers to the first buyer in a double sale situation involving registered land. So that's Bautista versus Fule. Bautista versus Fule will bring this all together for us in our head. So, registration under Section 113 of PD 1529 of an instrument relating to unregistered land would produce legal effect only if it is consistent with the principle of protecting a third party with a better right. Who is this third party? The first buyer in a double sale situation involving registered land. Okay? Okay. The rule on double sales under Article 1544, these rules are applicable to unregistered land, but only insofar as they do not undermine any specific rules or regulations that have a hierarchical that they're higher on the totem pole. They're higher in the hierarchy for enforcement value. Why? Because again, Civil Code, General Law. In the case of Carumba versus Court of Appeals, Carumba versus Court of Appeals, here the applicability of Article 1544 is distinguished based on like whether the land is registered under the torrent system or if it's unregistered land. Okay, so under Carumba versus Court of Appeals, here are the rules. First, registration in good faith is applicable to unregistered land because the purchaser of unregistered land and a sheriff's execution sale are the purchaser of unregistered land after a sheriff's execution sale only steps into the shoes of the judgment debtor and merely acquires the judgment debtor's interest in the property sold as of the time that the property was levied upon. So that would be under Section 35, Rule 39 of the old Rules of Civil Procedure. So the 1997 rules, which states that the purchaser at public auction shall be substituted to and acquire all the rights, titles, interests, and claims of the judgment obligor to the property as of the time of levy. This overrides the provision of Article 1544 when it involves unregistered land, since under Act Number 3344, registration of instruments affecting unregistered land is without prejudice to a third party with a better right. In the case of Radio Finance Company versus Palilio, whatever. Under the Torrent system, it is the act of registration that operates to convey and affect registered land. Therefore, a bona fide purchaser of registered land at an execution sale, in spite of merely stepping into the shoes of the judgment debtor, because that's the rule for public auctions pursuant to the rules of court, then this bona fide purchaser of registered land would acquire as a good title as against any prior transferee if such transfer was unrecorded. So, if a person is dealing with registered land, this person is not required to go beyond the register to determine the condition of the property. He is charged only with notice of the burdens of the property which are noted on the face of the register or certificate of title, unless shit is sketchy as hell. Then do some investigating. So, again, how are the rules of double sales under Article 1544 applied to unregistered lands? The rules on double sales under Article 1544 are applicable to unregistered lands, but only insofar as they do not undermine any specific rules or legislations that have a higher hierarchical enforcement value. And again, who is the third party with a better right? In various cases, it has been held by the court that a better right is defined as more than just having in their favor an earlier deed of sale, but rather it is a mode by which ownership is directly affected and other existences, the existence of other facts and circumstances in the situation are appreciated, where the first vendee can be said to have a better right against the second purchaser, such as through acquisitive prescription or one who has taken possession of the property bought either by actual or constructive delivery. So it's more than just having an earlier deed of sale, but rather it's seeing like, ooh, is there any way that the ownership was like that a mode of transferring ownership was actually affected? And you look at the facts and the circumstances to say that, like, yeah, first vendee actually got it, or like who has the better right? Was there acquisitive prescription? Was there actual possession, delivery, yada yada? Okay. The global rules on double sales. The first is registration in good faith under PD 1529. This is the highest order of the rules. Absolute priority is given to the buyer who has the registration in good faith under 1529. So buyer who has that in their favor gets absolute priority. But registration in good faith cannot apply to unregistered lands because they're not registered, okay? And what are you registering? The sale. So you're registering the sale to attach to that title that's already there for the registered land. The second global rule on double sales. Principles embodied in the rules of court as to the risk being taken by the highest bidder at a buyer at an auction sale. So if it's an auction sale, there's separate rules for purchasers there under the rules of court. And these pertain only to cases involving unregistered lands. So if, say, this is the situation, two conflicting sales, one of which was executed before the land was registered, and the other was executed in favor of a judgment creditor of the owner, because in the time that has passed, the property had been registered. Okay? So, one sale, land unregistered. Second sale, land was already registered, and the purchaser here was the judgment creditor of the owner of the land. Now, the Section 35, I think old Rule 39, of the rules of court on execution sale would then apply. Since the land was previously sold to the first... Okay, it's the same principles, but like the numbers have changed. So don't quote me on this, but just listen. Since the land was previously sold to the first buyer, the second buyer at the execution sale actually bought nothing. Why? Because the first sale was already done. So by the time that the second sale happened, the judgment creditor had nothing to buy because the owner of the land was no longer the owner. They didn't own that anymore, so they had no rights to sell the property because it had already been previously sold to the first buyer. If the property covered by the conflicting sales were unregistered land, okay, if they were both unregistered, then the first buyer would undoubtedly have had the better right in view of the fact of such claim being on the basis of a prior sale. Now, if the property was duly registered for both sales, then the second buyer at the public auction would have prevailed, since the registration of the deed of sale would have been the operative act that gave validity to the transaction. Now, the subsequent registration of the land between the sales was a technicality that could not have rendered ineffective the previously unregistered sale and the conveyance of title and ownership in favor of the buyer, especially when the first buyer had already taken possession of the land and conveyed as owner thereof and introduced considerable improvements thereon. That's in the case of the Gupan Trading Company. Okay, so basically, if it was unregistered before and you sell it again, and then it's registered now, just because that person gets the title doesn't mean that the previous sale would be invalid, because that would be a way to escape that, which would be super gnarly. So don't let that happen. Under Act number 3344, registration by the first buyer is constructive notice to the second buyer, and this can defeat his right as such buyer in good faith, and that the registration of the instrument involving unregistered land in the registry of deeds creates a constructive notice. Because what do you register if the land is not registered? The instrument. Okay? And this serves as constructive notice to bind third persons who would still may subsequently try to deal with the same property. Subsequent registration by the second buyer would not cleanse that defect in her title, because the instrument was registered. That counts like, okay, so she's no longer in good faith, the second buyer. Now, the rules on double sales under Article 1544, again, give the principle of registration in good faith as the operative act, read together with PD 1529. Now, this goes beyond just contracts of sales, but also includes priority rules covering other forms of transactions, such as liens, encumbrances, involuntary dealings with registered lands like attachments and executions. In addition, the priority rule under 1529 would cover even contracts to sell and other processes within the preparation stage. Okay? The chain theory protects the title of the purchaser in good faith and for value from one who derives his title from one who had a void title. Again, this is just this just sort of sums up some of the rules, but basically, if you understand this future self, then you don't need to quote the chain theory. But basically, the title of the purchaser in good faith is protected. So if you're a purchaser in good faith and for value, this is protected from one who would derive his title from one who has a void title. Okay. Now, there are some tests under Article 1544, and this is the last part of this reviewer. There are about 14 or so situations under case law where 1544 is not applicable. Okay? Now, 1544 should be read with the idea of buyer beware. So when you're purchasing real property, it involves a lot of money. Yes, you can rely on the title, but even then, the Torrens title, the indefeasible character of it, still has to be read with certain circumstances. If you're buying a hacienda in the back alley and the guy's in a trench coat, maybe be a little suspicious, you know? There is still caveat emptor, let the buyer beware. So the one who purchases real property, if it's actually in the possession of others, maybe you should be like a little bit, inquire, make some inquiries concerning the rights of those in possession. Maybe those are the actual owners and you're dealing with a fraud seller. So the case of caveat emptor requires that the buyer be aware of the supposed title of the seller and that he who buys without checking the seller's title. So if you didn't do your due diligence, and sometimes certain situations require you to be a little bit more diligent than just checking the title. Anyway, and that's the mirror doctrine. But there have been some cases where the mirror doctrine has been, I think, getting more and more diluted. Whether or not that's a good thing, I don't know. We live in an age of scammers. So, he who buys without checking the seller's title takes all the risks and losses consequent to such failure to check. Now, when does Article 1544 not apply? Obvi, when not all of the elements are present for a double sale to be there. Maybe the guy sold two things, but they're actually two different plots of land. And then that's not a double sale. The guy just made double his sales. Now, when also does it not apply? Now we're going to run through about 13 exceptions, and these come from cases. Is it super important to remember all of these? I don't know, but let's run through it. I don't know how many times I want to go through this. If not, I'll just I'll probably only do this once. So just reverse future me when you want to listen to this. Anyway, first, the two different contracts of sale are made by two different persons, one of them not being the owner of the property sold. Why does it not apply? Not all of the elements are present. Second, the sale involves unregistered lands under Act Number 3344. Registration of documents affecting unregistered lands is without prejudice to a third party with a better right. So if the sale involves unregistered lands under Act Number 3344, registration of documents affecting unregistered land is without prejudice to a third party with a better right. Okay? Mere registration of sale in one's favor does not give him any right over the land if the vendor was not anymore the owner of the land, having previously sold the same to somebody else, even if that earlier sale was unrecorded. The principle of prior tempore potior jure, he who is first in time, is preferred in right, should apply. So, if someone else purchased that land, even if the sale was unrecorded, mere registration by the second vendee does not give that vendee any right over the land because the owner of the land was not actually the owner of it anymore, okay? It had previously been sold to somebody else, even if the earlier sale was unrecorded. Okay, next. The first sale occurs when land is not yet registered, and the second sale is done when the land is already registered. Then the principle of first in time, preferred in right, should apply. If the another exception is when the property is registered already under the torrent system, then the first buyer's registration under the torrent system, then the first buyer's registration of sales under Act Number 3344 is not effective for purposes of double sales under Article 1544. Okay? When the property was already registered under the torrent system, the first buyer's registration under the torrent system and of the sales under Act Number 3344 is not effective for the purposes of Act Number 1544. Thus, the second buyer would prevail over the first if the second buyer had recorded the sale in good faith with the Registry of Deeds in accordance with PD 1529. So this is when the second buyer would prevail. Okay, because the first buyer, here the land is registered. The land is registered, and then the first buyer made an ineffective registration of the sale. Okay? Then the second buyer who registered it properly and in good faith, remember, good faith has to be here all the time. If there's no good faith, fuck you. All right? Get out. Get the fuck out of here. That's the case of spouses Abrego versus De Vera. Not the fuck you part. Seventh exception, when the owner had previously sold their property, so dominion has transferred, and then therefore executed a second sale in favor of another person, then the latter cannot acquire any right. Okay? Ooh. Oh no. You already sold your property, but then you're like, ooh, what if I just sell it again, even if I don't have it anymore? The second sale, the latter cannot acquire any right, because at the time of the second sale, the vendor had no more existing right over the property, which he could lawfully dispose of. Remember, when you're talking about double sale, they're both valid sales. So if, for example, the vendor had no legal capacity by the time the second sale happened because they were no longer the owner, it wouldn't fall under double sale. So these exceptions make total sense if you just understand what a double sale is. Okay? Because you're talking, again, over the mode of acquiring ownership. You're talking about the consummation of that sale. Both of the sales are valid. But who gets to actually own the thing? Because someone disposed of what they own twice. Okay? Next one is Number 8, when the earlier transaction is a pacto directo sale of an unregistered land and the subsequent conveyance is a donation of the land in favor of another by the vendor a retro. Again, earlier transaction, pacto directo sale. What is the land here? It's unregistered. Then the subsequent conveyance is a donation of the land in favor of another by the vendor a retro. So then double sales not apply. 9th exception, when there's only one valid sale. No shit! Then there's no double sales under 5044. So there's only one valid sale. Why? Because the previous sale was found to have been fraudulent, or if one of the sales is simulated and the other one is genuine. Because, again, 1544, you need both to be valid sales transactions. 10, when one sale is absolute and the other is a pacto directo sale, okay? And the period to redeem has not yet expired. Why? Because the other one, it hasn't been consummated. It's not at that stage yet. So there's no double sales yet. One is an absolute sale, the other one is a pacto directo sale, and then the period to redeem has not yet expired. 11th exception, where one of the sales is one of the sales is subject to a suspensive condition. And what happens with a suspensive condition? The happening of the condition is what makes the obligation exist, versus if it's like a period, which affects not the existence of the obligation, but it affects the demandability, right? The demandability. So here, the sale is subject to a suspensive condition and there was no compliance with this yet, and the other is an absolute sale. Same with the pacto directo situation, okay? One is conditional, so it's not yet a sale, really, until the condition has been performed. And a pacto directo sale is not really a sale until the period to redeem has yet expired. It goes still into the fact that there have to be 2 or more transactions, and they're all valid sales. 12th, when one is a sale and the other is actually an assignment of the right to repurchase the same property. Same element affected here. Where one transaction is a sale and the other is a mortgage. Same element. And then lastly, in a contract to sell, this is Coronel versus Court of Appeals. In a contract to sell, there being no previous sale of the property, a third person buying such property despite the fulfillment of the suspensive condition this person who buys the property despite the fulfillment of the suspensive condition for a property where there was no previous sale of this property and they've entered into a contract to sell. I just repeated what I just said backwards. Anyway, this person cannot be deemed a buyer in good faith, and the prospective buyer cannot seek the relief of reconveyance of the property. Okay? So really, just remember that the nature of double sales in Article 1544, both of the sales involved in the dispute must be valid or at the very, very least voidable. Okay, so that is it for double sales, and then going also into the rules and systems that govern in case of registered and unregistered land. Okay, bye.